Hello students, there is a good news for you. Now you can write the same matter at different speeds. Link of the same is given in the description box. Thank you. Start. As admitted by the complainant, he is a printer, publisher and writer of newspaper magazine and the complainant did not know him earlier to this incident. Stop. Hence, the complainant did not know anything about him earlier to the alleged offense and the entire facts are not revealed that there is no intention to damage the reputation of the complainant. Stop. Para. He did not have any intention or enmity to commit the offense under section 500 of IPC against the complainant and the same has not at all been appreciated by the trial court and the said fact is even not noticed despite arguing this aspect in length. Stop. Para. The trial court has not understood the evidence of the complainant. Stop. The trial court has failed to understand the proceedings and considered the evidence of PWs 4 and 5 who are Tehsildar and Revenue Inspector. Stop. In respect of these witnesses, he went up to High Court and the Honorable High Court dismissed the applications of the complainant filed under section 254 and 91 of CRPC seeking permission to call PWs 4 and 5 as witnesses of the complainant and their evidence were automatically discarded in view of the said order. Stop. Para. Despite the fact that the evidence of PWs 4 and 5 was discarded, the learned magistrate has considered their evidence also while giving finding without understanding the case and has passed the impugned judgment and convicted him. Stop. The trial court has also considered the documents which are said to have been produced by PWs 4 and 5. Stop. When their evidence itself should not be considered, the trial court has erroneously considered these exhibits also and has not considered the order of the Honorable High Court, which can be understood that the learned magistrate has gone against the directions of the Honorable High Court. Stop. Para. The trial court has not looked at all into the cross-examination portions of PWs 1 and 2 and nothing is discussed about the same in the judgment. Stop. The trial court ought to have considered the evidence of PWs 1 and 2 only but has wrongly and illegally considered the evidence of PWs 3 to 5. Stop. The trial court has specifically stated about the exhibits and considered the same while passing the judgment, which is wrong and illegal, and the same is considered without understanding the case. Stop. Para. The trial court has not understood the implication of the provisions of sections 499 and 500 of Indian Penal Code and passed the impugned judgment with a prejudiced mind. Stop. Since the trial court has not at all considered his defense, the issue is before understanding the law and the facts of the case. Stop. Para. The trial court has not considered the cross-examination portion of PW2 wherein he has categorically admitted that he does not know as to whether the reputation of the complainant was damaged or not. Stop. PW2 has not at all supported the case of the complainant and these facts are clearly elicited from the mouth of PW2. Stop. The trial court has not considered a single fact of the defense while passing the judgment. Stop. Para. In response to the due service of notices in both the appeals, the respective opposite party oblique the respondents put their appearance through their respective counsels. Stop.